started recording, so please do not swear. And there we go. Right, so I am ever so pleased to welcome Björn Lundqvist to Southampton Law School and the Centre for Private and Commercial Law. Björn is a distinguished professor in EU law and competition law at University of Stockholm, Sweden, by the way. Björn is also, in case you don't know your geography, Björn is also the director of the Swedish Network for European Law Research, and he's a board member of ASPOLA, the Academic Society for Competition Law, as well as their Nordic representative. And Björn's research has always been anchored around competition law, but over the years he's sort of explored how these rules impact and intertwine with other areas of law, such as intellectual property law and data protection. His book, Standardization under EU Competition Rules and US Antitrust Law, propelled his career and research further into the realms of standard setting, not only in relation to intellectual property rights, but also regarding the digital economy, interoperability and market access, looking, for instance, at cloud services as the ultimate gatekeeper, just to mention one of his many, many articles. Björn now has a new book, Regulating the Data-Driven Economy under EU Law, Access and Transfer of Data, which promises to be equally exciting, and as usual, Björn brings different areas of law together in a new perspective. So without further ado, I'll hand it over to Björn.
Thank you very much. That was a very kind invitation, presentation. Yeah, thank you. I'm very happy to be here to present my new book, Regulating Access and Transfer of Data under EU Law, I would say. Tell you a little bit about the background. I actually started writing the book during the pandemic, because that was the first time I had some time to actually write something more, lengthier than just a short article. Especially in the beginning of the pandemic, it was few seminars and conferences, so that was really the time to be a bit productive, I guess. So it eventually wound up in this book. I'd hoped to perhaps publish it a little bit earlier, like before the Digital Markets Act and now the Data Act, and I will come back to that a little bit, but I've updated the manuscript during the whole period, so I do discuss these quite general legal system, which EU is now implementing together with a lot of other legal systems. One thing one of my conclusions is that we are really creating a new legal system in reference to data and the digital economy. So from a Nordic perspective, I would say it's a new market law, what we previously defined as market law. In German competition law, German law, I would say Wirtschaftsrecht, droit économique in French. So but catering to the digital economy. And I think it's interesting to notice that we do create a whole new legal system. Good. The outset of the book is then, maybe this is nowadays not so interesting to discuss it, but it is, I still think it's good to be updated. There is a little bit of a new paradigm that we are entering. Yes, we have had the internet for very many years, but when it comes to data and data access, we will soon enter the Internet of Things, where everything is actually going to collect data from us. Shoes, our cars are already collecting a lot of data. I drive an old Saab. It's not collecting any sort of data, but if you buy a new BMW nowadays, you cannot drive that without accepting it to pick up a huge amount of data from both how you are driving, but also from the road and the surrounding environment and so on and so forth. So we are really entering, I think, into a new era where all human activities, all activities will actually be measurable and collectible in data. And the question is a bit what we're going to do with this. And of course, it's an amazing thing where we can create a lot of innovations for it. But also that we might actually also face sort of different sort of problems and so on. Yeah, I think I'll leave it to that because I think it's kind of obvious for everyone that we're entering. My outset in the book when it comes to data is that like irrespectively how private and valuable we think it is, data as such is not covered by any sort of property right, at least not from a Central European system. I mean, we have intellectual property rights, we have copyright, and we have sui generis database protection, but data like the ones and zeros, so the different words and so on, is not actually covered by any sort of property rights. Yeah, no worries. That was a very large question, wasn't it? Yeah.
Sorry, we're back.
No worries. Yeah.
The same, thank you. Yeah.
What we call data has different sources though. And one thing, and I think that was the start of it all, maybe it's actually government data. So we had early regulations, what's called PSI regulations, which dealt with government data. Kind of, addresses to individuals, company register, trademark register if you trademark law. Those was all like digital, and actually a lot of authorities kind of made use of that to people had to pay to get access and so on. So actually government data was the first area of data where the EU addressed already in 2003 actually, where we had the PSI regulation about accessing that kind of government data for private actors to actually make use of that data and then innovate or something like that, and then create some kind of new innovation based on that digital or on that data. That has actually developed quite a lot, and now we have the Open Data Initiative, and our research libraries are actually encompassed by this now, and it's a whole area in itself actually, and needs a lot of research. I think whether that is a good idea or not. Should we actually give access for free that we do? Or is that because previously, at least the authorities in Northern Europe actually made quite a lot of money on this. That was actually running the whole authorities, like the trademark, the data register, and the company register sold access to law firms and junior associates when they're looking at who's the board member of that and so on and so forth. But nowadays they have to give access for free. There's some small exceptions. Then the other sort of data nowadays, of course, it's user-generated data that you collect from our interactivity on the internet, but also then a lot from now, in the future at least, from this Internet of Things. It's like everything we do would actually be generated on platform, or internet service providers actually collect a lot of data. Patient data, there's a new proposal for health data, which is absolutely amazing in its breadth and also depth from the EU, what we're going to do with patient data to cater to innovation and actually to research. But then we have web crawlers and cookies and whatever you have. Then we have voluntary provided data, of course, that we provide ourselves when we write and so on. And all of that we previously called big data, but nowadays we're taking away the big and now we just call it data. And of course, then it's really the new thing, which I don't really cover in the book, actually. You mentioned it, which is, of course, AI, this black box that you connect to the data, or you use the data to train your AI as they try to frame it, I think. Like AI is a person that you need to train, but of course, it's just the software. It's the black box, it's the software. And why I never really fancied AI, which I now start to understand the importance of AI, but is that I always thought it was about the data. You know, yeah, you can make your AI a little bit better than your fellow competitor, but it's all about whether the quality and especially the volume of data you have. That's the important thing, not actually your software, which AI is. But maybe I could be wrong. I'm not a technician, but that was actually my take on it. Now it also, of course, implicitly implied time and so on. How long have this AI been connected to the internet and it's trained or had access to all this data? Also, if you follow Harvard Business Review, there's a lot of talk about dynamic data, or that AI creates data that trains AI. And honestly, I think that's probably excellent for certain kind of solutions. If you feed it 1,000 pictures of cute cats, then yeah, it's going to create new cute cats. But I do think there's a market for real data, collected by ships or smart cities and cars driving around and so on. So, and I think that's probably in my world, I think that possibly is the most valuable data, actually, also to train AI and get AI to actually function in society. But that's a little bit the outside. And I am, as Hedvig, is from origin a competition lawyer. So I think a lot about market failures when I say if we need to regulate something, there needs almost to be a market failure. Or otherwise we can use competition law, or we have a lot of legal system we have is actually based on market failure. And in around 2020, it was a lot of discussions whether these large platforms and also perhaps the platforms who come, whether they actually represent the market failure or are they very efficient solutions. And on the competition law, we always valued efficiency. I mean, that's been the cornerstone to what we think it's actually something good. But coming from doing a lot of research already on PSI in 2003 and 2008, the idea behind that was always that, yes, we should open up government data. We should open up all the data to everyone to use, because that increases innovation. We have a future with all these data markets where people buy and sell data sets and so on. But interesting, we saw quite early that the large platform did not share that much data. They were making use of the data for their own services and also for developing their own services. That's quite natural. If you have this natural resource, it can be more lucrative to actually sell services which are based on it than to sell the raw materials. But that was not the idea, at least not from a legislative perspective when it came to data. And also, there'd be quite interesting research actually from the UK competition authority in reference to data. And they have this enormous final report from 2020, which dealt with the ad market on the internet. And it's like 1,500 pages or something like that. But if you scroll down to Appendix F, it's a very good appendix, actually. It's an excellent appendix because it indicates how the UK market is. And they actually pinpoint Google and Facebook to be the one that collects most data. And they don't only collect data from their own ecosystems, they also collect data from all other websites that use Google or Facebook technology. And their conclusion is that Google is worse than, like, if you live in the UK and you look at the 100,000 most popular website, 83% uses Google technology. So even though you're actively staying away from Google, you're still gonna give data to Google through those websites. And the conclusion is that at least when it comes to Google and Facebook, even I mean, you will give data to them if you go on the internet in the UK. And I warrant that there's the same thing if you go in Sweden or Denmark, I think. And they're not really sharing it. I think that's the interesting thing. Then the other ones are interesting too. But and if you look at economics, then whether is that a problem? If those large platforms collect a lot of data and don't really share it. And there are economists that talks about this hold-up problem and lock-in problem. Hold-up problem is actually an older term, implicitly implying that you are company connected to a platform or connected to a larger company, like you produce one part of the car, so to say, and you only have one car manufacturer that's actually a customer, and that implicitly implies that maybe you adapt your whole construction system to actually fit with the BMW car. And then you become bilaterally you're quite locked in, and you also you hold up. I mean, if you invest in it, they understand that, and then they can actually you're not allowed to charge as much as you can. And there are a lot of economists, and I think Jens Prüfer and Christopher Stockmuller that I think is quite popular also at both DD Connect and DD Comp. They talk about this that these economic theories fits quite well if you compare it to the situation where all data would be freely available, all small companies can make use of it to innovate and so on, and it might both create this hold-up and lock-in problem, but also this idea of like the problem of anti-commons, that you have this source of wealth that creates a lot of wealth, but it's not distributed evenly in society, and there are some gatekeepers that can actually refuse access to it, and thereby that source of value is not efficiently used in society. Yeah. So I do think there is basis in economic theory to say that maybe we should have a rule about access to data for certain industries and certain firms, especially perhaps if you're one of these firms and say, you're a manufacturer, or you make use of Amazon Marketplace, for example, which was one of the investigations which the commission had. You're a small designer from Southampton, and it's difficult for you to sell your stuff in Southampton to make a living out of that, but then you can go on Amazon Marketplace and you can sell it globally, which is an amazing thing. But of course, you're not gaining any sort of information. Who's your customers, and are they young and old women? What kind of shoes do they buy to my dress? What kind of books they read? What kind of food they eat? But of course, Amazon knows all about that. And the theory, at least, that with DG back then was that then Amazon make use of that, and they create a private label, and then they start out competing you because they know the customers better than you do, and they can put their private label in the best rankings. So when they buy their books, because they are the one actually catering to that kind of interest and so on, then they will buy. So you have this both a hold-up problem because they have all the information, but it's also lock-in problems because it's very difficult for you to leave Amazon market. Good. And the question is a little bit then, can we make use of competition law to grant access to all this data? And that's been quite discussed, I think. But back then in 2020, the idea was that competition law is not the right tool to use in the digital economy as such. It takes too long time to make use of it. It's too difficult to establish the relevant market. Even if we do render a decision, like in Google Shopping, for example, and Google has to pay 2.6 billion euros, they can still appeal it, and it's still in court now, even though we started to do the investigation in 2010, and now in 2024. And we're not creating any sort of legal practice here. We don't know what is the rights. So we need to create a sector-specific rule. And behind that was also this idea that, yes, competition law caters to like the old economy, where we have oligopoly firms or large firms, but they're producing one thing very efficiently. But now we have these large platforms that produces all kinds of services, and then competition law is not. I'm not so sure that that is true, but that was the general consensus. But behind many of these regulations, and now we do see that CMA, or the UK Competition Authority, but also national competition authorities in Europe are quite active. I mean, they do bring a lot of cases to court, and maybe not against the big giants, but also smaller platforms. And honestly, often the smaller cases create the best case law. It's not often that these huge cases create the best case law. But anyway, that was the idea. And then we started to create a lot of sector-specific regulations. And I put some of them here, but there are other ones too. And in the book, I try to argue that if you take this into consideration, we do see a new legal system being developed when it comes to the digital economy as such, and interestingly, very much relating to access and transfer of data. Like all of these regulations have some kind of regulation in reference to it. GDPR is, of course, a cornerstone in that. We have some old regulations that no one really talks about anymore, the data free flow regulation, and also DPS 2 people talk about that because that's financial data, or we give access to our banking details to fintech companies and so on. A lot of intellectual property, so data mining rules is quite new and so on. And then, of course, there's the trade secret rules, which through especially the Data Act, but also possibly the Digital Markets Act, also become quite applicable when it comes to data. Because companies, at least in the Internet of Things, claim often trademark protection on the data. Then there are cases now that says that that's not really possible, interestingly. There is a quite new case about Scania, the truck industry, which really create trucks that collects a huge amount of data from all different sort of sensors. And they didn't want to give access to an independent repair shop to get that data. And there's, I don't even have that regulation here, because it's also regulation for independent repair shop that they should get access to that data. And they claimed trade secret. So no, but it's not trade secrets. It's highly valuable trade secrets, which is now actually what it says in the Data Act. And the interesting thing, which I wasn't able to put in the book, but the court says, no. That regulation for independent repair shop, that right trumps the trade secrets rules. That is, when I wrote the book, I had I had a total different mindset. I thought, no, trade secrets. I mean, it's almost intellectual property rights. It's often protected by the constitutional rights. How can a small regulation about independent repair shop, how can that trump trade secret rules? But then the Digital Markets Act, Digital Service Act, what is coming for our competition law geeks is that at least in the Nordics and in Germany now, we have new rules which is called competition tools, which is, I think it's the economist's wet dream. It's what they can do. In fact, they do that. So they allow competition authorities to do sector inquiries, which the UK competition authority is one doing quite a lot. It's like a sector inquiry into a sector, into a business. And then the new rules gives the competition authority the right to regulate that if they find something which is wrong. So, and previously is that yes, it did an investigation, but then they still have to make use of Article 101 or 102 or the equivalent in the national jurisdiction. And so they need to, yes, we did, we looked at the ad market in the UK, Google, yes, you're doing something bad. Let's start a case if you're monopolizing or abusing your dominance. But the competition tool is going to say that, no, you did the sector inquiry, you identified that there's a problem in this market, then you're allowed to regulate. Which implies that even if they're addressing really like one or two players in this industry, they have no right to appeal that. It's not a decision which is directed towards them. So they are, because it's the legislator who created rules. So an economist would love that, because then they don't need the lawyers. They can just write the law. And then we have the data health data space, which I'm going to talk a little bit in the end. If you look at the whole system, they overlap a lot. And the Commission has not, in my view, or the EU has not addressed this issue. It's we talked a little bit, me and Hedvig, or Hedvig and I, when we were driving down it, that, so for example, digital markets, the result says, yes, competition law should be used, and we take a step away, but it really overlaps, I think, in many cases. And in practice, perhaps that's not a big problem. Like maybe you do based on the Digital Markets Act, which is a private action case, and then you as a second ground use competition law because that's too more complicated. So if it's not Digital Markets Act, the violation of 5.2, then at least it's something else. So maybe in that sense, maybe it's not a big of a problem, but it becomes quite complicated for the companies who are exposed to this, especially if you're allowed to do it under one act, but not the other, and how. At least it's difficult to communicate that as an in-house lawyer. So yes, it says that you can do it, but you cannot. And I think that's something for the courts to iron out for very many years, I think. We do create a new kind of rules. If we talk about the Digital Markets Act, and maybe you're all very familiar with that, it honestly is really like lex specialis. I mean, caters only to the large gatekeepers. I mean, it's quite difficult to fulfill the requirements. You need to have at least 45 million users a month. You need an annual turnover of 7.5 billion, or you need a market cap of 75 billion. So, yeah, we're talking about the GAFAs, the large US platforms. Also, I think ByteDance or TikTok are exposed to this. There's maybe hotels.com is a little bit close. And there are some others which are lying in the borderline, but otherwise it's not. But that's the entering, how you enter it. And it's been a huge thing now with the Commission, and if you follow that, because they have this seminar where they have to show how they fulfill these rules and so on. And those rules that we're talking about is Article 5 and 6. That's where the obligations are. And they are quite specific. Also, they are really based on investigations conducted by the Commission, especially DG. So they had competition law investigations, which most of them, they didn't actually run, or there was no decision in the end, but they didn't really doesn't matter because you did create what I call a blacklist, what you're not allowed to do. 6 is what I call hard gray. I mean, it's a blacklist too. You need to follow it. They can squeeze it even tighter and make those obligations even more tough on their own. This, so if you violate, you have to pay 10% of your global turnover. System, it can actually, it can run even structural actions. From a competition law perspective, there is no efficiency defense. I want to stress that there is no exemptions, which is quite odd. So if a gatekeeper comes to the authority and says, yeah, I'll do this, but I mean, all the customers love it, it's super efficient, and so on. And then the competition authority or DG Comp can say, yeah, I agree. But you know, we are so bound by you, by DMA. I mean, DG Comp doesn't have a magic efficiency exception. There is none. I mean, so you cannot. I mean, that whole argument is not going to fly. Not even the commission, if they want to, can exempt something from this. So I think it's quite interesting actually how rigid these obligations are. And then of course you have list of prohibitions, and I don't know if we need to go through them in detail, but they originate from different. I think at least from different sort of investigations and so on. Yeah, MFN, right, parity clauses and so on. And then Article 6 is quite similar. A lot of them, we'll come back to them, caters to access and transfer of data. A lot of them are not. Most of them are vertical. Not that many. It's just like one is horizontal, and it's about Google search that they need to give access to the result software to other search engines. That's the only one who's actually horizontal. It's an interesting obligation, so to say, but it's the only one who is. Yeah, it's horizontal. I can come back to that.
Yeah. Can I ask the question?
Sure.
So for Article 5 and 6, is that, because when I was looking at it, I was a bit, well, I don't see any sort of initial rhyme or reason as to why one type of behaviour has been placed underneath 5 in comparison to underneath 6. Like I don't. Or maybe it's just me who's about it, but I don't see the logic of why one has to be underneath the blacklist and why one have to be this hard grey. You don't know either. Like it seems a little bit random. Some of the
I agree. Maybe these are more clear cut because Article 6 you can get individual decisions which caters to a specific gatekeeper. I mean, if you take the parity clause, I give the commission that's not so complicated. But even though it's a very tough rule, but if you look at this, for example, there was the Swedish, French, and the German Italian competition authority investigated this for many years. Price parity clauses. So, and it's hotels.com. Can hotels.com, can they have, you're not allowed to have a cheaper price on your own website. If you're a hotel, that's one clause, price parity clause, you need to have the same price there. And then it's the add-on, you cannot have a cheaper price at another hotels.com equivalent. And then the question is then, is that a broad, narrow price parity clause? And 3 of those came that narrow price parity clauses is fine, broader is not okay. And that was, well,
It's just
It's annual or monthly.
hope so. It's just a test, isn't it? Yeah. That's just a test.
But now the commission just took away everything. So there's no price parity clauses. When hotels.com fulfill these rules, then they are need to oblige. Then they can have hotels that which is on their site, which pretty much indirectly say, well, you know, yeah, find us on hotels.com, but please go to our website. Yeah. And maybe these are more a little bit more complicated. But I have if I come back to that the question because in the book I look at all the obligations, but I'm focusing on access and portability of transfer of data, and that is actually 5.2, 6.2, 6.9, 6.10, and those I find interesting. And first with 5.2, I combine personal data from relevant core platform service with other services, also by the gatekeeper, or with personal data from third-party services. This is Google. They're not allowed in their ad tech service to use personal data that they collect from us when we do the search and combine that with the data they pick up from Google Maps or from other third-party search. And that, I mean, that's really a tough law, I would say. And it's really in the ad industry, that's really because one of the innovations which Google had said that yes, you know, if you put an ad in our system, we can actually provide you with some kind of indication of the result of that ad, because we can follow the individuals on the web, on the internet, see if they're buying product, but we can also through Google Maps give an indication whether they're actually in real life when to buy that. And that was amazing. It's a really good service and now they're not allowed to do that, which I find quite interesting. 6.2 says, yes, Google or Amazon Marketplace, if we take that designer in Southampton, yeah. Now, Amazon Marketplace cannot do this. They must refrain from using in competition with the business user data and not publicly available, which is generated or provided by those business users. So if you generate data from selling your dresses or your line of clothes on Amazon Marketplace may not use that data to compete with a private label, which was Linda.com's big article from Harvard Law School, but also not really substantiated with evidence, but it was investigation also with DigiCom. And I also think is that also that so the gatekeeper needs to provide the business users free of charge with effect because it's real-time access with that data that they're not allowed to use in competition with you anymore. And also, if you get it, you can also actually get portability rights, implicitly implying that Amazon Marketplace has to delete the data if you get it. That's how I read portability, at least. It's not only transfer. And then I look at these and I said, well, aren't they? If we look at it from a property perspective, aren't they telling us something who actually owns this data, according to the DMA? Yeah, no, it's the business users that actually own this data, even though we don't have a property regime. And they are the one that actually should make use of this data. And then the question is a little bit, and this I've been I'm discussing quite in detail. Can we use DMA as a private action? Can that designer in Southampton, can she go to city court and claim that data? Because then it becomes even more property rights. Or is the DMA, as the commission seems to imply, only their tool, which they can play around with? I'm not so sure. Honestly, I think it could be used for private action. They did talk about private action, but then it was only about the damages. But also, I think you can actually make use of them as a weapon for gaining access to. And there might be a difference between 5 and 6, because 5 are there. 6 can need a decision individually for each gatekeeper. And then my private action falls, I think, but I'm not sure. Because it's all about basic EU law. It's about direct effects of EU law. This is EU law. Does it have direct effect? Well, it depends if it's obvious and clear cut, and I don't remember the requirements, but no, or it's not obvious and clear cut, but it's something similar. So I think it's an interesting tool. If we come back to the Data Act next, and then I can stop there. Data Act is the next big data regulation. And compared to the DMA, now we're talking lex generalis. This should apply for everything, like the whole Internet of Things. This is the legal system we have. It applies to the smallest producer and to the biggest producer. It's an exception for SMEs. So yes, in some aspects, but otherwise, and the Commission talks about lex generalis. So this is lex generalis, which I understand. So if it's not regulated in the DMA, we fall back on the Data Act or competition law, because I guess competition law is also lex generalis, but otherwise we fall back. Yeah. It's a huge act. It's 200 pages. Very specifically regulated. I wouldn't. From a Nordic perspective, and then it would be even more from a UK. From a Nordic perspective, such specific rules as we have in this act, we haven't had since the 1970s. I mean, there are rules, especially when it comes to cloud computing. Very few actually venture that far, because it's Chapter 3 and Article 23 to 29. It has, I would say, price regulations that we have in the 70s. Like, you're allowed to charge full price, but if someone exits within a year, then you're only allowed to charge half that price. It's just pricing regulations to some extent. So and one need to understand as a private lawyer, the Data Act, especially Articles 3 to 13, which is the first, which is access and transfer of data, and also this when it comes to cloud contracts, it's actually mandatory contract law. Which you need to have in the contract, which I find very odd. It's go the contract rules to stipulate that someone has rights. I could be wrong in this, but that's how I read it. And now we don't have the UK in the EU anymore, but previously private law was not something that the EU dealt with. It wasn't. I should say it's outside the authority, but it's on the borderline. And especially, at least from private contract lawyers, I think they're quite surprised by that. I mean, we had those consumer directives, blah, blah, blah. So there are contract law regulations too, but this is and for example, if you, I've never done that, but if you, like Article 13, which stretches over 4 pages in this regulation, is an unfairness rule for business to business transactions. So if a business whether business needs to transfer data or not from the manufacturers and so on and so forth, and that's quite alien, at least from a Nordic perspective. We have very few unfairness rules for business to business from the start, but this is really going the whole way in that sense. Very good. And there's Fran. Having said that, I wrote a book about standard setting body, standard setting body. I mean, it's the most litigated issue ever in patent law. I think I'm on statistics, but I think that's it. Yeah? And now we put it in for data access. Yeah. And also they set up a dispute resolution body. It's a whole new kind of court system. You can still go to court, but it's very very long. Article 3, so they start with access and transfer data. Article 3 said all products should be designed and manufactured and should be provided that related services. That's DMA. Or that could be a gatekeeper if you use Google Drive. In such a manner, the data generated by the use, are directly accessible to the user. So that's the requirement. I don't know how many will actually abide by that. But if you don't, then there is, and then you use the word right. And you have a right to access and transfer your data. Contractual rights, but still a right. And then that says Article 4 and 5. There are some restrictions, I would say, which we already had at the DMA. We didn't write it out at the DMA. It was very unclear about intellectual property law in DMA. Could Amazon say, no, it's my trade secret? Yeah, we talk about trade secret, but also I have Linux database protection. I put this in this database, and you want the whole database, and that's my right. I mean, the Commission doesn't really want Linux database, and they try to make us forget about that, but it's still a right. We're still in there in the law. Also, I think a big issue is GDPR. And the funny thing, there's probably some GDPR experts, yeah, but I think GDPR is a very odd legal system. It really didn't really fly the way we might have thought that would work. In essence here, and also in the DMA, GDPR is really a tool for large gatekeepers to say no to data access. They're like, no, we cannot. How we interpret GDPR, this is personal data. So it becomes almost like an intellectual property rights in this sense. Also, what they snuck in there in the very last, Sweden was actually the presidency when this was snuck in, is security. No one really talks about this, but this is a black hole. Apple loves this, I know that. Because if you encryptate everything, can you use that exemption not to give access to any sort of data? So we're going to have a lot of fights about access to data, which you have a right. It says you have a right there. You might be able to go to court to do it, but there are a lot of exemptions, which the manufacturers or the data holder, as they're called in the data, may utilize not to give access. Good. Yeah.
Yeah.
Oh, sorry.
That's all right.
Yeah, I just want to. I just mentioned this, especially because I think UK lawyers are different, and I think one thing is very strange about the Data Act, very odd from an IP, intellectual property law perspective. And this is the doctrine of exhaustion, which is not an IP, it's a trade regulation. So the idea of doctrine of exhaustion is that you buy something, then all rights to that falls. And I mean, in the basic one in Northern Europe is if you buy a house, then no one can come and claim that they have any sort of rights to that. I mean, if it's not written into a legal act or something, then So for example, I mean, if you buy a plot of land near an apple tree, it's not like the seller can 6 months later come and say, oh yeah, by the way, now I'm coming to pick up my apples. You're like, no, I bought this piece of house with an apple tree. Those are my apples. Huh? But the funny thing about the Data Act is totally flipped around. Here, this point of departure for all Data Act is that the manufacturers always have right to all data that is generated by the car or house or truck or whatever you stole to someone. That's the baseline. It's so much baseline that they don't even put it in there. Their whole idea is that, yes, they collect the data, and you have a right as the purchaser to also have access to that data a bit. Is that all? I think, so maybe it's not available here. But I'm not so sure that this is not been litigated. Because I know, for example, ABB, CRB is a huge company, creates a lot of stuff, but they also create a power line between the engine and the propeller of huge tankers. They had a lot of sensors in that. They were monopolists. And they had this place in Norway somewhere, which was like a high, like a space center, where they followed all the ships all over the globe. And they could, instantly understand, yeah, you need to go into service, go to that harbor. I mean, it was a service that they provided. But then there were some Greek ship owners who said, I bought that ship. That's my data. That's my engine running. Why are you looking at that? So there is some basic property rules that I think are available. Then, of course, there's a lot of, already mentioned, a lot of limitations where someone could stop granting access to data. Some have been taken care of, so the database right is not applicable in the data. And there's a security limitation as well. So that I'm not going to talk about anything more than that, I think. So what I'm doing in the end of the book is I said, maybe we don't need such a very complicated system with all these general sector-specific rules. If at least for what I'm looking at with access and transfer of data, maybe we could create a property right, a new sort of property right, or well, we don't need you have to call it a property right. We call it an access and transfer rights, when you can access and transfer data or not, and not all these sector-specific rules, but a general rule. And maybe then we don't need so many specific sector-specific regulation, because I think it gets very, very complicated. And also this thing about doing through contract law, I'm not so sure about that. I think that creates more problems. And we start there, then maybe we don't need all this other add-on rules. There's a lot of add-on rules here. For example, in the DM, a lot of other obligations, but maybe if the data is the core thing, which it seems to be a lot of these different sectors, maybe that's the thing we need to regulate. That's where the hold up and the anti-commerce were at the beginning, which the economists talk about. I mean, that anti-commerce problem is not different for different industries. Could be the same in all industries. So that's my conclusion in the end. Sorry about taking too long. Thank you very much.
Questions? Anybody want to have a go?
Thank you so much for this really rich and thought-provoking presentation.
Yeah, thank you.
And it's quite admirable how you were able to digest basically a significant number of seemingly very distinct disciplines, including competition law, intellectual property law, data protection law, online platforms, etc., etc.
I'm cheating a bit.
It's quite a challenge for us legal scholars to be able to get a holistic understanding and understand how these regulations interrelate. I think you explained really well the relationship, the bidirectional interrelationship between data and the Internet of Things, where we need data to feed into Internet of Things, but then Internet of Things and AI applications generate new data. So we feed data, and then we have more data, and then that data is fed again, and that keep having that cycle. And I'm trying to understand whether you're basically arguing as to whether the basic distinction between personal and non-personal data is no longer a meaningful and useful concept, and we should perhaps move away towards a more general understanding of data and create a bundle of rights towards them. So I would be interested to hear more about that, whether you have any thoughts.
I think that's an excellent question. I don't think we should separate it. I think personal data. Firstly, technically, it's very difficult to separate non-personal data with personal data, and the Data Act and the Data Act, but also the DMA does not really make a difference. I mean, they do make a difference because they mention the GDPR and say, is it personal data, and then so on and so forth. But as a general level, they don't make a difference. And I do think that's the way to go. But then I'm not a real fan of GDPR. I think GDPR has become a tool for people more to prevent data access. And specifically certain firms. So then I do see the need for it, but sometimes you're more expert than I am. I could go for a GDPR, which is very tough when it comes to really large data holders. But if you're a small data holder, then maybe there should be no requirements. Because I think the risk is with the large data, not the small ones. And I think we regulate it too horizontally. Then I know it's different rules for small and also the GDPR, but we should make that more distinctive. But I think it's the right observation from you that I don't make a difference really. Then yeah. Yeah, also.
Yeah, I mean, yeah, this is fascinating. It's not remotely my area.
No.
But it's still very interesting. You mentioned that SMEs are excluded. I'm not familiar with all the different regs that you're talking about and so on. So SMEs are generally excluded from most of this regulation.
From the Data Act, yes. And it's a general trend in the EU to exclude everything, the SMEs from everything.
Yeah.
And I'm not so sure that that's a good idea, but maybe that's your question.
Well, yeah, because from the corporate side, well, sort of see generally in the corporate side, there's a big pushback against all of this EU regulation at the minute.
Yeah.
And so the political response is always to exclude the SMEs on the basis that most jurisdictions, at least 80% of their business activities are SMEs. So if you exclude them, you dilute a lot of the political.
True. That's a good observation.
But also in this context, you know, one of your initial slides was about Microsoft and Facebook and Google and so on. So is it really that all the regulations should be concentrated on these, I don't know, there are 10, 20 global huge platforms, and that if we sorted that out, that it's not that important to come down to deeply regulate the rest? I don't know, maybe that's a superficial.
No, I think that could be a good idea, but I think it's a little bit difficult with SMEs. I did a study for the DG Comp on SMEs because they wanted to exempt them generally as a group exception, and And the definition of SMEs in EU, I don't remember the exact numbers, but it's quite high. So and I think it exempted like 98% of all Italian companies.
Yeah.
So it's a huge exemption if you don't think about it. And then there are certain jurisdictions like Japan has a very sophisticated system of accepting SMEs. But then they do a biannual analysis of where to put the turnover in different industries. And that seems very complicated to me to do. But maybe you can do it in that kind of society. But in Europe, I think that would be difficult to do. But maybe you're right that like a DMA catering only to very large entities is the way to go. Then the Data Act is very broad in process, but of course I'm thinking out loud, but the cloud chapter, so of course it's the same gatekeepers we address, honestly. So
It's just also, I mean, the link to that is really about enforcement.
yeah.
Because I think that's the other interesting thing, your point about whether, private actions might be possible. But because again, just to give the corporate, have to give the corporate angle, because there are these new sustainability directives and due diligence.
Yeah.
And one of the issues that's really not been answered yet is whether it will be possible for private actions. And actually from the corporate side, they're worried about the litigation risk.
Yeah, I guess, yeah.
So if you've got a litigation risk, it does, maybe for not these huge companies like Google and so on don't care, but if you just go that step down from them, the very large ones are worried about litigation risk and reputation risk.
True.
And in the boardroom, it's a corporate governance issue. So like, I just fascinated to know what, to what extent the boardrooms are worried about these measures and potential enforcement against them.
Mm. So I've been contacted a little bit with Apple and they are quite, they want to fight back.
Yeah.
And they want to put the angle and say, we're also profit-driven companies. So and we're going to make use of these rules as much as we can too, not to, and so on. But it seems a bit different between different gatekeepers. I think Google are more protective of the brand than Apple is. But then Apple has this corporate structure that they want to keep everything inside there. So I think it differs from company to company. I do think that they're afraid of private action. They should be. So the biggest ever court case in Sweden is in Stockholm now, and it's Price Runner, which was a Google shopping competitor. They sued Google for 20 billion euros. They have no. I don't think they got any. But anyway, it's so I would be nervous. A lot of talk, a little bit talk at least of taking away this 10% to the fees.
Yeah.
Because it doesn't really prevent them. No, it's too little and so on. Also, if you take GDPR and those issues, I think what is becoming more and more obvious is that the national authority, I think this is different in the UK, right? From small European countries, they are not keen on addressing large platforms because they don't have the resources. So if they start a case against Google, and even if they put all the lawyers and the authority in that conference room, Google is still going to put twice as many in there. So that's a problem with GDPR. And then they actually go after the mid-level.
Yeah.
And they get all the, attention, and that's odd, I think. That's odd that we have some companies who become so large that it's very difficult to address them.
But that's a common problem in the legal system.
Yeah, and maybe it is.
If wealth and power insulates you from enforcement.
Yeah.
It's the tier below.
Yeah, it's the tier below. Yeah. But I think it's very interesting that the due diligence that you take on.
Yeah.
And also that, because there was some in the draft of private action.
There was, but they're gone.
They're gone, yeah.
Yeah.
Okay. But they were far reaching.
Yeah, yeah. It raised a lot of blood pressure.
Yeah. Because it wasn't really a violation of human rights. It was just, yeah. Wow.
But the political pressures changed all of that.
Oh, they took it all.
Yeah, all gone. And in fact, even in December, when there was still an element of this left, actually the French and Germans, by all accounts, were the people who said, actually, we've had a rethink, and they were in favour of it, but in December, they changed that. And then they've been negotiating since, and it's now been adopted, but it's completely diluted. Politics as well as law.
It boils down to a larger issue, I think, and Vestager is a little bit the source of that. This idea that companies should not only make profit, that they have a social responsibility. And it's interesting to see it in every legal system. It just hits it. And as having an competition lawyers, and competition law build on the notion that they are striving for profit. The whole legal system doesn't really fly if we don't. And I think it's the same with many corporate law too. We need to rethink our whole way of doing it. And now it's. I forgot something. We had. So in the Data Act, and this was when Sweden had a president. So we talk about trade secrets. I just want to say that they put in this exemption for very valuable trade secrets. If it's not a regular trade secret, it's a very valuable trade secret, then you don't need to give access to data to a user. What that is, we don't know yet. That's a new form. Or whatever.
On the question. Yeah, that was really very interesting, fascinating presentation. Thanks, Björn. Just had a quick question. So with regard exactly, so there are all those rules which are a bit confusing. They argue in favor of a bit of streamlining, right?
Yeah.
Which makes a lot of sense. And so obviously the focus now is also to understand how existing rules are being applied. Because many of them have still to be transposed. Do they contain provisions? Because you looked at the rights, contract rights, other provisions on enforcement inside the act saying, liability, private, something like that, the act then itself. And then the second question is, maybe that's not really like the point you were covering here. And so, this is not really, it's a bit out of scope, but it seems like there's a lot about this consumer law, right? So I was wondering, what is the overlap there? Yeah. Because you mentioned all those laws, but actually a key one, which is the consumer. Yeah. How does it overlap there in this sense? Because there's also this private enforcement reason against at least this would be a really big kind of.
No, that's an excellent question. Yeah. So I'm not a consumer law expert, then you're more better than I am. But I don't. But there are a lot of individuals we're talking about this, especially if you're the purchasers of that BMW, or you are not the purchase, but you lease it, and the leasing company is the user, or you the user. I mean, who's the user? So there are definitely a lot of consumer law here. How that fly with the rest of the consumer law legal system, I'm not sure about actually. So Antonina Bakajeva, who is a consumer law lawyer, we've tried to get funding to get some, they talk about this. Also with this health data, it's very interesting, I think. There's a new health data proposal regulation. So it covers our patient data anonymously. So it's not pseudo-anonymous, it's not all anonymous. But it also covers all private health data from our watches. So both private and public data is going to go up to the same authority. It's coming back to these new authorities, which is going to be created in almost all these legal systems. It's specified authorities, which we don't know if they're specific new authorities or if the member state can give it to the competition authority or some other consumer authority or something like that. And there you have definitely a lot of consumer issues, both in reference when you buy those health tools, but also as a consumer of healthcare in one sense, because that all that data is going to be accessible, and that regulation has no exemptions whatsoever. And it says in the beginning, intellectual property law should not be applicable when it comes to health, which is, I think that, but we see with the pharmaceutical companies, I think it's going to fight back on that. So because I mean, they are the intellectual property law holders in society. So, yeah, seriously fight. But there's clearly that I think many of these acts, there are specific authorities. And maybe the Data Act has that in the very end there, and specific authorities, appointed authorities that should be, whether that's going to be consumer law or the consumer authority or not, I'm not sure about actually. I only know that in Sweden they have now a collaboration, which is not as a confidential collaboration, it's a competition law, consumer law authority, and data protection authority. So we meet every other week to discuss cases and so on. And it's quite interesting. Depends on your constitutional view of authorities and if they actually can share data in that sense. But they do actually. Yeah.
Sorry, just a provision that might interest you is a very strange provision in legislation we passed in October called the Economic Crime and Corporate Transparency Act. And there's a section in it which simply says any person may provide information to the registrar of companies to assist her in performing her functions. Any person. And there's no other limitations. Whereas normally to transfer data between regulatory authorities, you typically have to find the gateway in the relevant legislation.
Sure, yeah.
So for example, to transfer to the registrar, you have to find a provision, usually in an appendix to the Act, saying you can transfer to these people, the Bank of England, the Financial Conduct Authority, the Registrar of Companies, and so on. And you have to find the gateway to do it.
Yeah, exactly.
But this legislation in October just says any person.
Well,
It doesn't even say any regulatory person. It says any person may transfer, may provide information to the registrars. This strikes me as bizarre.
yeah.
No constraints. Weird. Sorry.
No, I think authorities have an issue of this, whether they want to share information or not, or are they obliged to do it. No. But the consumer law angle is something to worth looking at.
Yes, thank you. So, I think you mentioned about a case about a specific truck manufacturer. Yes, so in relation to that, I can see it aligning with the financial ombudsman in the UK, which is basically for deciding financial services related disputes. So specifically, I think you also mentioned about telematic boxes being implemented in vehicles. So these days, like insurers are actually using that to determine premiums.
Yeah.
So if you complain about that, if you feel that you are being unfair, if your premium is being unfairly determined, The decision generally says that this is something of a commercial data and we cannot share as to how the pricing was arrived upon by the insurer. Now, my question here is whether this can come under the ambit of, let's say, public policy, because public interests are being involved. Without seeing like public policy from the perspective of arbitration laws, where specifically like patent rights are not something you can arbitrate, given that a lot of public interest involved in patent rights. So I'm just trying to see whether public policy can be one argument to get this data out to consumers, or at least the reasoning or the logic behind arriving at that decision.
Yeah. So I think normally how the insurance companies access that, isn't that through contract, they have a contract with the consumer. But let's say they don't have that. So they then, well, let's say they have a contract, but there's no stipulations about it. Then under GDPR, I would say they could get the right to access to fulfill the contract or whatever. Or and also there's this public, public reason exemption for accessing that. Whether they can use that, I'm not the expert to tell you. I don't know that actually. Means commercial data. I would look at the Meta case, so the Facebook case from the court, because Meta had that argument. I mean, they had an argument to fulfill the contract. And I think they had a public thing too, like at least in the German court, and see what they say about that. Because, yeah, to me, it's a very, to me, at previously it was very narrow exemptions. It's almost like the government saying that we need to stop the flu epidemic to access. But that's what I say. But it's yeah. I think it was further developed in the UK just with the insurance companies, that you agree to them checking how you drive and you get a smaller fee. And I think it's an interesting system. One could argue against it, is that the whole idea of insurance is that you shouldn't know that much about the users. And it is a collective thing. So everyone pays in and then everyone gets something out. And then inside that system, of course, you will always have the people who are more, less duty of care than others. You see what I'm saying? But then that whole idea was actually, from the legislative perspective, it was yes, but then we have this collective system, so we take care of them during that. But now if we can collect data from everyone, then of course that disappears. Then everyone has to pay its fee. You have your own bank account where you put in one, if you know how big yeah. I'm exaggerating a little bit, but it's yeah.
Yeah, I believe they use the term information asymmetry for this.
Sure.
Given that insurers might know more about the assured itself.
Yeah, that's interesting. Yeah. True. Yeah. Thank you.
Yeah. I just wondering if any of the people online, if they had any questions. I don't want to leave you out. No? Okay. Any more questions in here? No? Because then I think we're going to stop. We've gone well over time, but I think it was, because it was so interesting. Well, there was a lot of questions as well, wasn't there? Yeah, no, it was really fascinating. So thank you very much, Björn, for coming all the way over from Stockholm to
it's not that far.
entertain us.
Yeah. was,
It's very much
it's very nice
appreciated.
to be, I never get to talk.
Yeah.
Thank you for everything.
Thank you.
You presenting it?
I just started this.
Oh, okay, so I'm not presented yet, okay.
This is